has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they were to be provided, and he said no. And I asked you at sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, aren't the ABA guidelines the counsel are supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware of that.
In regard to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages leading up to trial when I was told that by you that there was a pause email and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided, pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarized all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her texts and the text of her text messages. There is nothing else in existence to provide, and importantly, the defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have, and in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently, we've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved. And there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February 19th, we finally get the raw images from Aperture and the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images and scans. We move, and we have a hearing on March 20, 2025, to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it. And by March 24, we receive the PowerPoint that was of the Aperture that was supposed to have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes were.
So why don't you highlight them very quickly, because I
will, Your Honor. I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the tail light was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report, and then the last 2 items, we renewed our request to preclude Dr. Welcher on Delbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial. 6 months. And the defense took merely 2 days after they got the final report of Aperture to retain ARCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post-haste. And they are working post-haste, but, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript, albeit on an electronic device, right in front of me. I just got to get the passcode. Mr. Jackson read a text message right live that he had with ARCA. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week but not next week, so I really need to get her in on Friday. Mr. Jackson.
Hold on.
Yeah.
Court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you. All righty.
Go ahead.
Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week but not next week, so I really need to get her in on Friday. Mr. Jackson, Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages, as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
So I need you to wrap it up because there's something I want to say.
Certainly, Your Honor. I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order, and with regard to the retaining of ARCA, because we're the defense, we acted expeditiously in response to the information we're getting, and this can be tested with ARCA, this statement I'm going to make. To this date, ARCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCA to bring all these items with them. So Friday will be for ARCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk through ARCA and I've got to understand what they have and what they don't have. So I think, in fairness, I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order, hopefully before the close of business today. Jimmy, can you stay and get this out today?